Are recording.
All right, thank you very much. The appellate court is back in session. Good morning. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube as well. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Elgo.
I'm Judge Cradle.
I'm Judge Suarez.
James Mortimer.
And Robert Darrington for the respondent, appellee. Thank you.
Thank you. Thank you very much. Now, counsel, prior to this argument, you received procedural instructions for this hearing. Are there any questions before we begin?
None from the petitioner appellant.
None, Your Honor. Thank you.
All right. Thank you. Now, for the record, I note that I can hear and see everyone. Please let us know if in the course of the argument you're experiencing any difficulties hearing or seeing the participants. If your video should go out, please continue arguing. If for some reason we cannot hear you, we will pause to address the issue, and it's recommended that perhaps signing on and signing back off may help address a technical difficulty. Unless there has been prior permission or there are sudden technical difficulties, those arguing must keep their video on and remain in view out of respect for the process and the participants. Do keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question. If you don't see them, I will endeavor to call your attention to that fact. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Suarez has kindly agreed to be our timekeeper today and will give you a 5-minute warning and I believe a 2-minute warning when as your time is transpires. We will now hear the matter of it is St. Pierre versus the Commissioner of Correction, and counsel, you may proceed.
Good morning, Your Honors. Again, my name is James Mortimer. I'm assigned counsel for the petitioner appellant in this habeas appeal. May I please reserve 5 minutes for rebuttal?
You got it. Thank you very much.
Thank you. And Your Honors, I do not anticipate going the entirety of my 15 minutes with this case, as it's a relatively straightforward matter arising from a habeas trial wherein the petitioner alleged the respondent was deliberately indifferent to his serious medical needs. The issues throughout the course of the underlying habeas matter did become a little narrowed in that the respondent, to their credit, did address some of the petitioner's habeas concerns and medical needs throughout the course of the underlying trial, which spanned, I believe, somewhere in the vicinity of 6 months. So at the outset, I believe there were 3 primary issues raised by the petitioner appellant, and that was with respect to the department's attention to his medication regime, to his physical therapy, and to footwear that the petitioner requires. The petitioner's underlying habeas trial evidence that he suffers from what's known as complex regional pain syndrome. That's formally known as RSD, which is how the habeas court refers to it, and I do believe that's referred to as both kind of interchangeably throughout the underlying proceedings. This is a rare neurological condition which causes a petitioner extreme hypersensitivity to touch and pressure, things of that nature. The petitioner also suffers from a shoulder injury. There were 2 shoulder injuries that he had subsequently developed issues relating to, which has kind of been exacerbated in terms of pain by his complex regional pain syndrome. Additionally, the petitioner had undergone a number of foot surgeries and suffers from continued issues with one of his feet, which has led to the requirement that he remain in a wheelchair, and that's how the petitioner essentially gets around. So with respect to the complex regional pain syndrome, this is being treated exclusively, as Dr. Jonathan Koss testified to at the underlying habeas trial. It's being treated exclusively by medication, or was at the time of the habeas trial. And this medication regime involves the use of both Oxycontin, which is delivered twice a day, and intermittent or as needed oxycodone, which is referred to as his breakthrough medication. The breakthrough medication is where the petitioner has repeatedly encountered issues, as evidenced throughout the proceedings below. The petitioner has had repeated delays and confusion in the medical line as to when his breakthrough medication is delivered and whether it's appropriate. Mr. Rich Fury at the underlying habeas trial did make some affirmative efforts to address a confusion in the medical line, and I do believe that was resolved. However, the petitioner did continue to have issues even throughout the course of this matter with respect to the receipt in a timely fashion of his requested oxycodone doses. And the manner in which this affects the petitioner, as Dr. Cost and Dr. Wright had testified to, is the OxyContin has a period of effectiveness in which, after a period of time, it becomes less effective, and the petitioner requires this breakthrough medication to kind of alleviate the pain that he's suffering from. And that is really the only manner that DOC has been able to find to address the petitioner's pain. Yes, Judge Ugwell.
Counsel, I guess I'm unclear. Even if the court found error here and this was remanded, what relief are you looking for?
We're asking simply that the petitioner receive, concerning this particular claim, that he receive his breakthrough medication in a timely fashion as it's prescribed on an as-needed basis.
Is that, I mean, of all of the issues that are being that were being raised, is that the chief one that you believe remains?
Yes, Your Honor. We do
Okay.
believe that is the most significant issue that persists after everything that has been done.
And remind me in terms of the specific issue, that the factual issue that relates to that claim, was that the problem with the nurses being timely? Is that
is exactly the issue, Judge.
okay?
There has not been any issues with respect to the administration, right? And okay. I do believe that the evidence below demonstrated a certain level of caring that came through from Dr. Wright and Mr. Fury concerning how the petitioner is treated. And it's really the administrative staff in terms of the delivery of this medication where the petitioners expressed or encountered repeated problems. And
did the court, though, credit, I forget which witnesses, I believe it was the doctors, who attributed, some degree of the delay due to a number of logistical issues, emergencies, a variety of problems that contributed to the delay?
Yes.
And so why is that clearly erroneous?
Your Honor, I do believe that evidence also demonstrated issues, admittedly from Dr. Wright, concerning the confusion with respect to the delivery of his breakthrough medication. And although some of these issues have been resolved, as a petitioner I testified to extensively, it's encountering confusion among staff members as to when he should be receiving his medication. There were certainly issues related to lockdowns, movement issues, things of that nature, which created delays. But yes, Judge Fredo.
You're muted.
I'm sorry, Judge. I think you're muted.
I'm trying to get off mute. This is a issue. I just want, for clarification, I thought at some point they were trying to take him off the breakthrough medication to give him I don't know if I'm saying it properly, Belbuca.
That is correct, Your Honor. There was some testimony concerning the petitioner being transferred to Belbuca, which is a non-opiate medication, which could have alleviated some of the other problems attendant to his heavy opiate regime.
So is he on that now?
Well, as of now, he is not. I think that kind of evidence a bit of a disconnect there with respect to the manner in which his pain is being managed, in that it seemed the evidence suggested that the left hand really doesn't know what the right hand is doing, from both Dr. Jonathan Cost to Dr. Wright. Dr. Wright had never heard of the Belbuca, or in terms of it being recommended for the petitioner. And the same kind of disconnect was evidenced from Dr. Wright's testimony concerning, he realizes that the petitioner needs his medication as needed, and that's how it's prescribed, but he's not at the pharmacy and doesn't know what's going on there in terms of the delays. It just seems like a bit of a bureaucratic interference, so to speak, in terms of the petitioner actually receiving the treatment that's prescribed.
How does that amount, though, to deliberate indifference?
Well, Your Honor, I think under the circumstances of this case, the habeas court erred in its conclusion with respect to there not being a pattern with respect to the petitioner not receiving his medication on time. I think the evidence below indicates of the essential pain relief medication, which is the only thing that alleviates his significant pain, demonstrated by the department as well. It's just been an ongoing issue and reoccurrent issue. So under the circumstances of this case, that's what we would submit would amount to deliberate indifference, is that DOC is certainly aware of this problem, but they've done nothing to address the delivery of medication. These 1.5 to 2 hour delays the petitioner continues throughout the course of the habeas trial to suffer from. So it's that particular issue that we would submit amounts to deliberate indifference, in that measures have not been undertaken by the department, despite being aware of this issue, to address the petitioner's as needed medication. So I also would indicate that the evidence below demonstrates the petitioner's treatment was certainly something that was constantly in flux. And I think counsel for the respondent and myself encountered issues in that this transpired over a period of time, nearly half a year or so, in which there were changes made to the petitioner's treatment regime. And likely that's going to be something that continues. But as for the time being, we would simply ask that the court order that the respondent provide the petitioner medication as prescribed. And certainly that's subject to change, in that he may shift in what medications are prescribed. If new innovations come to light in the future to treat this rare neurological condition, certainly that may change as well. But in terms of the petitioner's imminent need, that is for timely medication. And as I would submit that I think that the Estelle case does support our position, in that case specifically indicates that the timely delivery by personnel on the ground, not just the doctors and the administrators, but they have an obligation to make sure the petitioner is being treated as prescribed. And that, we would submit, is not occurring in this particular matter.
Are you saying that he's then at times he's not getting medication at all, or he's getting it later than he's supposed to get it?
I think the habeas court's finding in terms of there being delays, it was appropriate in this case. There were certainly some issues with respect to the petitioner not receiving his medication, as he testified to, but it's more of a repeated pattern of delay.
Right, but you did concede, though, some of that was cured during the course of the habeas trial, correct?
The issue of the timely delivery of medication was not alleviated during the underlying habeas trial. It's just been an ongoing issue. There were issues with respect to the petitioner's mattress that the department addressed, as well as the conditions in his cell, which the petitioner had testified to, and that Dr. Cost had also testified to, that the pain he experiences is like a burning sensation. DOC was, they provided him a secondary fan to allow for cooling of his skin. And there were a number of conditions that were, in fact, addressed by DOC throughout the course of this, but a persistent issue has been the timely delivery of his medication.
And when you say the delay, is that delay a daily thing, or is it, how often is this delay that you're claiming?
The delay, I believe, in terms of it varies in terms of there's not any schedule or any kind of like repeated exact pattern. I think between the second to final and final day of this underlying habeas trial, there was an indication of there were 4 to 5 occasions when the petitioner was delayed an hour and a half to 2 hours with respect to the receipt of his medication.
4 to 5 occasions where there was delay?
Yes, Your Honor.
Okay, and how often is he supposed to get this medication?
He receives the breakthrough medication twice a day as needed, and that's between the administration of his OxyContin.
So there's been only 4 or 5 times that there's been delay when he gets administered this medication twice a day? Oh,
no, that was
I'm confused.
That was between the second to last and last day of the habeas trial.
Oh, okay. I'm sorry. Okay.
That's quite all right. And it was a tad confusing in terms of these issues being logged by the petitioner or by staff in terms of the frequency. It's not something that can really be anticipated, in that issues arise within the institutional setting, or the petitioner will have to, depend on a variety of variables in terms of his ability to get into the medication line, wait for the medication line, and then receive the medication, hopefully from the distributing personnel at the medication line. So,
can you state whether or not the record reflects what percentage of these delays were not attributable to these logistical problems, emergencies, other issues that the court identified as just being inherently problematic?
Well, that's an interesting point, Your Honor, because the record's relatively unclear with respect to what caused the given, particular delays. There was an incident wherein the petitioner had sought medical attention, which we submitted was kind of demonstrative of how he's treated by the department staff, in which he was left effectively in a room for hours and ended up leaving to go treat himself when he was suffering from some weeping and bleeding blisters, in that the petitioner seeks help, and then depending on staff, he does not receive it promptly.
Judge Suarez? Oh, okay. All right. Go ahead.
Unless this court has any additional questions with respect to the petition.
Sorry, that was the wrong side.
Okay. All right. I guess your time is up, Attorney Mortimer, but you will have, I believe you reserved 5 minutes. Is that correct? Okay. All right. Attorney Darrington.
Good morning, Your Honors. I'm Assistant Attorney General Robert Dearington, representing the Respondent Commissioner in this case. The judgment of the Superior Court should be confirmed because the petitioner cannot show that the trial court's findings were clearly erroneous. The only issue at trial was whether DOC was deliberately indifferent to the petitioner's medical condition that causes chronic pain. The standard here is whether the trial court's ruling was clearly erroneous, and as the record demonstrates, there was an overwhelming amount of evidence showing that DOC went to great lengths in order to treat the petitioner's medical needs. One of the issues that the petitioner raises was with regards to his shoulder treatment. But the record demonstrates that there was ample evidence to support the trial court's finding that that DOC was not deliberately indifferent to his shoulder. And there's just a laundry list of things that DOC did to treat his shoulder, which included X-rays, an MRI, 2 referrals to an orthopedic surgeon, a cortisone injection, 2 physical therapy consultations, and a wedge for his shoulder. He was considered for surgery, but ultimately the surgeon did not consider him a candidate for surgery at that time. With regards to the pain management, the trial court's decision was also clearly supported by the record. And there was an overwhelming amount of evidence about what exactly DOC did to treat the petitioner's medical condition, which was a rare and complex condition And so that what they did was they referred him out to Hartford Hospital to treat him to the pain management clinic. The record indicated that he had 11 consultations with a pain specialist to treat his RSD. As part of the treatment, they put him on numerous types of pain medications that were administered throughout the day. They also provided him with numerous forms of specialty treatment, such as Calmar therapy, an OSCA device, cognitive behavioral therapy. As Dr. Koss testified, that there's only limited things you can do for this rare condition, and DOC was trying everything. And when one thing didn't work, that they moved on to the next form of treatment. So a great deal was done to try to alleviate Mr. St. Pierre's pain. The petitioner argues that the trial court erred in finding that DOC was deliberately indifferent, primarily in regards to the administration of his pain medication by DOC's nurses. Despite the petitioner's claim, the trial court's decision that DOC was not deliberately indifferent was amply supported by the record. With regards to a deliberate indifference claim, there are two components that the petitioner must satisfy. The first component, the subjective one, requires that culpable intent on behalf of the respondent. The second component, the objective component, requires that the deprivation be sufficiently serious. First, with regards to that subjective component, the court found that any of the brief delays were caused by, as Your Honors stated earlier, the institutional demands of running a prison. And as Your Honor pointed out earlier, that the court credited Dr. Wright's testimony in that regard, and he testified about the numerous types of situations that could unfortunately result in Mr. St. Pierre's medication being delayed. And those were dosages being in short supply or temporarily unavailable to DOC pharmacies, events such as lockdowns, inmates requesting medication at nighttime, misunderstandings or confusion among nursing staff, which are quickly fixed whenever they're brought to the attention of the doctor, and the fact that there could just be one nurse administering medication to 10 to 15 inmates at a time. So, unfortunately, there could just be delays caused by the demands of running a prison. As such, the trial court's finding that the petitioner, that the respondent was not deliberately indifferent, is amply supported by the record with regards to this subjective component. With regards to the objective component, when there's an allegation regarding a delay in treatment, the analysis is not the seriousness of the underlying condition, it's the seriousness of the alleged delay. And in this case, the court found that any delays were, quote, brief. In his memo, the petitioner argues that these brief delays satisfy the objective component. However, the petitioner has not brought forth a single case showing that a, quote, brief delay in receiving pain medication satisfies the objective component. The petitioner argues that the delays range from 1 to 2 hours. However, the court in this case never made any findings regarding the duration of the delays other than, quote, brief. But even if the court did find that the delays were 1 to 2 hours, again, the petitioner has not provided any case showing that a 1 to 2 hour delay in receiving pain medication is sufficiently serious under the objective component. The petitioner cites to a 10th Circuit case, Al-Turki versus Robinson, which in that case, the facts are totally different. In that case, the inmate was suffering from kidney stones for approximately 5 hours, and medical staff refused to provide him with any treatment. And during those 5 hours, the inmate complained that he collapsed, he vomited, he believed he was dying. And that was also a fact. So factually, that was different, but procedurally is different as well. It was an appeal from a summary judgment. So it was just, a matter of whether there were material facts in dispute on appeal. But in this case, the court held a trial. The court was entitled to weigh the evidence, make credibility findings, and ultimately conclude the way it did, that DOC was not deliberately indifferent to the petitioner's medical needs. With regards to the petitioner's third claim regarding the DOC's medical care was his footwear. Again, the petitioner failed to show that the trial court's decision was clearly erroneous. The evidence adduced at trial showed that DOC made numerous efforts to address the petitioner's foot care needs and presented him with multiple options, including orthopedic shoes. And if he didn't like those, they also provided him with a sneaker pass so that he could order his own sneakers from outside DOC. There was also testimony that the petitioner had received diabetic neoprene sneakers in the past. Dr. Wright testified that it was his understanding that if the petitioner didn't like the orthopedic shoes, that he had the ability to order shoes using the sneaker pass. And the evidence showed that the petitioner, had spent $2,500 recently, so he had the funds to afford that. Additionally, Dr. Wright testified that he was looking into buying outside sneakers through DOC's purchasing clerk, but it's unclear if anything came of that. But even if the petitioner was unable to buy sneakers from outside DOC, the court's finding was that there was no medical evidence that those additional outside DOC sneakers were even medically necessary. So in light of all this evidence, the trial court had plenty of was within its right in deciding that DOC was not deliberately indifferent to the petitioner's medical needs. One last thing I would like to address is that an attorney, Attorney Mortimer, stated that he believed Mr. St. Pierre was not currently on Belbuca. I was advised as recently as last week that he actually was on 2 forms of medication, one of them being Belbuca. So I just wanted to raise that as something that I was advised of, but I just thought that was something that I wanted to address. But however, in this case, the trial court weighed the evidence and appropriately found that the petitioner failed to show that DOC was deliberately indifferent to his medical needs. This case boiled down to a simple disagreement with DOC's medical care, which cannot form the basis of a deliberate indifference claim. Unless the court has any questions, I'd rest on my brief. Thank you.
I don't see any. Thank you very much, Attorney Darrington. Attorney Mortimer.
Yes, briefly, Your Honor. With respect to the petitioner's shoulder injury, Attorney Darrington had mentioned the steps DOC had undertaken to provide various forms of relief for the shoulder injury. Nothing has worked with respect to what DOC has attempted to do aside from medication. And this is both with respect to a shoulder injury as well as the complex regional pain syndrome. This is an issue that's been essentially solidified as a medication treatment case since 2018 when Dr. Wright started taking care of the petitioner. So to the extent that DOC had tried things that didn't work in the past with respect to treating his pain, I don't see how such would be relevant to the court's consideration, as nothing has worked. This has been simply a case where the only means of providing the petitioner any relief from his significant pain is going to be medication. And DOC has an obligation to ensure that the petitioner receives his medical treatment in a manner consistent with how it's prescribed. And that is simply not what is occurring in the underlying case. Although there's been what the court termed brief delays, again, the petitioner would submit that delays of in the vicinity of 2 hours is not brief when you're experiencing significant pain that can be managed to some degree through the course of medication. Now, with respect to the petitioner demonstrating culpable state of mind by medical staff in the department, we would submit that we met that burden here, in that Dr. Wright, for example, DOC medical staff in general has been aware that this is a case wherein the petitioner needs to be treated with medication, breakthrough medication as needed, because the OxyContin is not going to provide continuous relief for the petitioner. So they have an obligation to ensure that it is timely delivered to him. Now,
well, but being aware is not enough, correct? It's being aware and then ignoring the problem, which is not what we have here, is it?
Well, the petitioner would submit that DOC has continued to ignore issues relating to the timely delivery of his medication, and that the department knows that this is a continuing issue. Dr. Wright had testified to it.
The court did not find that they ignored it, right?
Well, the court had essentially determined that the brief delays did not arise to a Eighth Amendment violation, and we would submit that the court erred in that determination, in that DOC is aware and has done nothing to address these delays with respect to this breakthrough medication. So the respondent has indicated the petitioner failed to point to a single case with respect to an analogous situation. This is, so the petitioner was unable to identify a single case dealing with complex regional pain syndrome. This is a rare issue. It's a rare condition, and unfortunately, DOC under these circumstances they have to take the petitioner as he comes and provide treatment that's adequate and sufficient to avoid him lingering in unnecessary pain. So unless this court has any additional questions, the petitioner would respectfully request that this court reverse the judgment of the habeas court and remand with direction to either grant the petitioner's petition or for further proceedings consistent with this court's decision.
All right. Thank you very much. I appreciate your advocacy on the part of your client's counsel. We will take this matter under advisement and confer momentarily, and we will recess until 11:30. Again, thank you very much.
Thank you, Your Honors.
Thank you, Your Honors.